Chapter 10, we finish up our contract series on contract law. So this one we deal with kind of some more unique specifications during the contract. So the first one talks about the privity of contract. So generally only the people who are mentioned in the contract enjoy the rights and the duties. But there can be different scenarios. So there can be assignments to the contract where somebody transfers the right to receive payment to a third party. So say if you're selling your car and you're going to get $5,000, that's your right to receive that $5,000. You could instead say, hey, pay it to my dad, or pay it to my brother or my husband or whoever. So you could assign your rights to receive that $5,000 to a third party, maybe that you owe money to or whatever. That would be considered an assignment of your rights. There can be a delegation of duties where you have a third party who performs the duties of the contract. So the key to that is it doesn't relieve the initial party, and it can't be something that really has a special trust and personal skills. So like, so say for example, there's a pitcher from the Cleveland Indians who's amazing and everybody loves him. Well, he decides, well, I think I'll transfer my duties to this pitcher from the minor leagues. Well, obviously you can't do that. Or say, you go to a concert and you expect to see a specific performer. They can't delegate their duties to somebody else. You just paid a certain price to see them. So those types of scenarios that are very unique to the person cannot be delegated. But say you just have a landscaping company who comes and mows your lawn. Well, maybe the guy is going to be on vacation for 2 weeks, so he delegates his duties to another landscaper. So they've got the same level of skill, same equipment. They come out and they mow your lawn. Now, the key to it is, though, say something happened, you would still go after that original landscaper. The person who you had the contract with is who would still be liable. So it doesn't relieve their liability. Then you can have contracts that actually specifically name a third party to benefit from the contract. So like a life insurance contract. So you say, okay, if this is a contract between me and the life insurance company, but if I die, my children are going to receive my life insurance proceeds. So they would be third-party beneficiaries. And so then they would be intended. So then you go on to say, okay, well, there's different levels of third-party beneficiaries. Intended beneficiaries are the ones that I specifically name. So my children are my intended beneficiaries of my life insurance plan. Or my husband, whoever it may be. Then an incidental beneficiary is somebody who is not, they're going to receive benefit from this contract between the two parties, but they can't legally enforce it. So say I give the example of, say, the Stark State College is adding on a new building and they want to find the same materials that it'll match our existing buildings. So maybe the same color of brick or the same, metal or windows or whatever. So we may use a specific supplier so that it matches, but our contract is really with the building contractor. We may recommend that they find windows that match or the brick that matches, so that there could be a third-party beneficiary that is going to incidentally benefit from the contract, but they can't enforce it. If we would say, oh, forget it, our enrollment's not going up, so we're canceling that building, that window company couldn't sue us. So how are contracts discharged? In the last chapter, I said by far it's most common to have it discharged by performance. So both parties do their end of the deal, but it could be by agreement or by operation of law. So for the performance side of it, it's an absolute performance is when both parties perform their side of the contract at some point in time. And that would be an absolute promise. A conditional promise is more of a contingency contract. So a common type of contingency contract is that condition precedent where we say, or precedent, where we say, like, I want to purchase this house, I'm going to make an offer, but it's contingent on the house passing a home inspection test. So if the home inspection test comes back and says, oh my gosh, the roof is horrible, you're not going to be able to get insurance, or you're going to have to put another $10,000 roof on, you could back out of your offer. You'd say, I'm done, release me from that contract. So it's going to be contingent on passing that home inspection test. It could be a condition subsequent that happens after. So say if, like when I first graduated from college, I got a job at Ernst & Young, the CPA firm. Well, part of the deal was that within 2 years, I would pass my CPA exam. I did. I didn't continue to work there, but if I say I hadn't, say I was continuing to work there and I kept taking the exam and failing it, they could fire me because that was part of the deal is I had to pass that exam within 2 years. Or there could be a condition concurrent. So to say, we need to be paid when those goods are delivered. So, kind of like a COD deal. Discharge by performance is when both parties complete their act. Complete performance, again, is perfect performance. It's exactly as outlined in the contract. Substantial performance is when there's just a minor breach. So it wasn't a big deal. The non-breaching party may be able to recover a little bit of damages for those deviations. So like I give the example of, say the person, say you have someone who comes out and paints your house and you say, oh, I specifically want this higher level paint, and they use a lower level paint or a more generic brand. Again, because it wouldn't be a huge major deal. Or say the something to do with, if you had some sort of home improvement project or some sort of work done to your car and you ask for something specific, but they use a different brand that's maybe not quite as high of a performance item as what you wanted, then they still did their job. They did it to the best of their ability. They just substituted something for something that you specifically asked for. Their performance is done, and maybe you could just get a reduction of the amount owed them. To the satisfaction of another, it always goes back to that reasonable person standard, because if you've ever been involved, like my husband used to do home improvement projects, sometimes it's very hard to satisfy people. So again, you have to go back to say, well, would a reasonable person be okay with this? Because if so, then it's been fully performed. But say it isn't. So say it isn't fully performed. It wasn't a minor breach. It's a material breach. So a material breach is when they fail to perform. So say you have a contract with somebody, that roofer, and you've given him money down. He never comes back, which you hear some of those things happen on the news. Well, obviously you would not pay him anything further, and you'd have the right to restitution to get your money back. You may have to find him, but he would be liable because of the material breach. A minor breach, again, I talked a little bit about it on the last slide, but say it's something that you think, okay, well, I'm not going to release my money until you come back and fix something. So say the roofer, say when the roofer put on your new roof, he did it, but then he damaged your front landscaping, or he drove the truck through your front yard. You might say, hey, I'm not going to give you the final amount that I owe you until you come and fix that. And of course, normally they would to get their money. But that would be an example of a minor breach. Anticipatory repudiation is when the person knows in advance that they're going to be unable to perform. So they give you notice to say, hey, I was supposed to do your roof, but something's come up and I'm no longer able to, so you may want to find another roofer. So you need to then do that, but you could go back and it would be considered a material breach. You could sue for damages for maybe the difference between the two quotes, or something along those lines. Then there's other ways that it can be discharged by agreement between the two parties. Rescission is when both parties agree to just terminate the agreement. So say you have a contract with a real estate agent to sell your house. It's been 2 months. There's no offers. You just think, you know what, we're done. I don't want to do it anymore. You tell them, I want to take my house off the market. They say, okay, that's fine. We'll just part ways. Novation is when there's a substitution of a third party. So say like with your landscaping example, say that landscaper that has been coming to service your house ends up getting another job or gets bigger and no longer can, or moves to a different area, whatever, he may say, I recommend this third party to come do it. And then he's released from liability at that point, and there becomes a new contract with that new landscaper. So in that case, it isn't just a delegation of duties. That person's totally out of the contract, and the new valid contract is formed with this new person. Accord and satisfaction is when you agree to something other than the original proposal. So maybe you're going to take somebody's stock, and instead of paying you cash, they're going to give you shares of stock or something like that, and you're willing to take it. That would be accord and satisfaction. Then, just like we had operation of law that terminated offers, you can have operation of law that actually terminates the entire contract. So if there's a material alteration in the contract, the innocent party would be discharged. There's statute of limitations that would say it has to happen in a reasonable time period. So again, say, like when you're selling your house, normally the contracts are like for 6 months or 3 months, that it's not going to go on for 2 years. That would be an unreasonable time period. Bankruptcy will discharge all debt, even if it's contractual debt, if the person goes into bankruptcy. If there is an impossibility of performance, such as death of one of the members of the contract, if the subject matter in the contract is destroyed, or again, if it becomes illegal. Then there's a fifth one that we didn't have with the offers, that is that it becomes commercially impractical to satisfy this contract. So sometimes there's industries like in the oil and gas industry or in our farming or agricultural industry, sometimes those products are set by a market price, so that market price changes, and maybe you enter into this contract and you don't have it subject to what changes in market. You have it at a fixed price. Well, then it may become commercially impractical. You can no longer get that product at that price. Or say it's a farm product and you've had a horrible hurricane season and the crops were all wiped out. Again, it becomes commercially impractical. That person could not fulfill their end of that contract. Then through operational law, that contract would be voided. So again, if it's a breach, we could go to court. What do we go to court for? We go to court and we seek damages. So normally it's money. So there can be compensatory damages where we are trying to get reimbursed for a loss that we actually sustained. So we can prove it, we know what that is. Consequential damages are resulting indirectly from the breach. So say if we ordered a part for our production line and we said, we need this Friday because we have orders that need to go out. We'll say it doesn't come until Tuesday. Well, if we could prove that we lost so much in sales revenue due to the 4 days that product, we did not have it, we could sue that, and that would be consequential damages. Punitive damages are always designed to punish the wrongdoer, and the courts will award those as they see fit. And then there can be nominal or miscellaneous type damages. Now, damages then could be mitigated. So then that's what the person's going to sue for, but that doesn't mean that that's what they pay for. So we can have some mitigating damages where the person needs to try to reduce their losses that arise from that breach. So they can't just say, oh gosh, you broke this lease and I'm out all of this money. They actually have to go out and try to reduce that loss as much as they can. Liquidating damages are sometimes set forth in a contract, and then it becomes a question of, are they liquidating damages or is it a penalty? So say, for instance, like when we used to have to sign cell phone contracts, and they would say, okay, it's a 2-year contract. If you cancel prior to 2 years, you're going to have to pay $250 or $400 or something like that. Those are liquidating damages where we know in advance that's what we're going to have to pay if we breach this contract. If it's so high that it becomes a penalty, then that is a different story. So say it's a mortgage, and they say, well, if you pay it off within a year, you've got to pay $10,000. Well, that's a penalty. It's kind of designed to punish. And then again, it needs to be a reasonable amount, but normally you do agree to that at the start of the contract. Some other type of remedies other than seeking damages, there can be rescission where we just want to undo the contract. We no longer want to be held liable. We don't want the contract to be valid. We want it done and over. Restitution is when the parties return the goods and services, the goods and properties back to the original parties. So everybody's returned to the state that they were prior to entering the contract. Specific performance can be used only for unique goods. So say I'm buying a sculpture or a painting or a piece of land that again is very unique, has trees or wildlife or rivers or whatever, and I can't just buy the one right beside it. Those ones you can actually sue for specific performance to say, I want that sculpture, I want that work of art, that's what I agreed to. Obviously, you could not do it for personal services. You can't say, I want that roofer to come roof my house. I mean, that would be considered slavery. We cannot force a person to perform services for us, even if we had a contract with them. That we could just go back and say, well, we're going to sue you for damages. So the specific performance would have to be for a unique piece of property. Reformation, we talked about reformation when we talk about like the covenant not to compete contracts, because those are ones that the courts can reform. If the court reforms it, they change the terms of the contract to make them reasonable. So they're going to say, hey, something's not reasonable in this contract, and we're going to make it right. And that would be considered reformation. Okay, so that completes all of our contract law.